Good afternoon, Your Honor.
Good afternoon,
everyone. Two things. I know I don't represent Mr. Huey or Mr. Nichols, but I presume that the state hasn't come close, this is how I look at it, to proving any type of conspiracy with them, but you included everyone, so I'm going to make the argument for everyone, but I just wanted to say that. In paragraph 51 of motion limiting number 51, paragraph number 4, excuse me.
Without waiving objection?
One more time?
Without waiving any objection, I'm looking at it right now. I have a copy of it.
Yes, sir. So what happens in those 2 minutes and 37 seconds of that call, October 22, 2015, it's not been played yet. State put us on notice of it, and I've objected to it on Friday when I got the state's 7 calls. This is not, so I don't know who the speaker is. So the speaker is clearly speaking with a person identified on the call as Mr. Winfrey. Mr. Winfrey's in custody, that's why the call is recorded. The unknown speaker says, pursuant to another unknown person, Mr. Winfrey will receive a Porsche vehicle when he is released from custody. That's what I've objected to. So, as you say, I don't disagree with anything the court said about the test. The declarant is not on the call. The declarant is an unknown person. The person on the call is unknown. So I don't know how that is a co-conspirator statement of a third party. It's double hearsay. That's what I wanted to bring to your attention in motion limiting number 5-1.
All right, I'll let the state respond to that.
Thank you, sir.
Because we did cover Cantwell a couple days ago in regards to non-party statements are admissible, and that was at 664F 4th 396 in terms of these other parties or unknown parties that are speaking to provide context. So I understand that you're asking it's considered hearsay. I've considered that, but this would be an exception to that.
And the context is always like if the Honorable Mr. Matthews said to me, how much money do I bring to the drug deal? And my response was, bring $500. My response would make no sense unless Mr. Matthews is not involved in the conspiracy, he's working with the government or whatever.
Understand.
That would make sense. But here it is the person on the recording saying that another person, I don't know who these people are, Your Honor. Another person said that there'll be a Porsche vehicle given to Mr. Winfrey. So the context is really not anything here. The substance of the statement comes from a double hearsay declarant. That was why I brought it to your attention.
Okay.
Understanding, and honoring, but not waiving. That's why.
Yeah, I understand, because you're saying it's hearsay, and then the state's saying, well, it's not. It's an exception to that being its co-conspiracy.
They might say that, but we'd like you to decide it.
I'm sorry.
We'd like you to decide it.
Yes. Okay. All right. State.
Thank you, Your Honor. Your Honor, consistent with what the court just spoke about regarding the law and co-conspirator, this particular statement is furthering.
Which one? Be specific. Which one are you talking about?
The statement.
Winfrey phone calls, or the Instagram.
No, we'll talk about the Winfrey phone calls first, Your Honor.
Okay.
The Winfrey call, which is this call that's about 2 minutes, in which the unidentified declarant is an unidentified co-conspirator, because in that statement, what the declarant says is, we'll sit down for $250,000 in a Porsche. And Mr. Winfrey doesn't say no. He doesn't say anything. He says, okay, that's my boy. That's my boy. My boy ain't never changed. And so, Your Honor, that statement is furthering the conspiracy as far as concealing what occurred in the conspiracy, which is we will sit down, we will be quiet, we will not say anything for this amount of money. Now, whether or not that happened or not, whether or not he got paid, whether or not he got the Porsche is of no consequence. But this conversation here shows that there's a covering up of the conspiracy, that conspiracy being 1, the gang, and conspiracy 2 being the actual shooting of the bus, Your Honor. And so we believe that this would fall under the co-conspirator hearsay exception.
Are you going to identify the speakers on the call?
We'll identify Mr. Winfrey. I believe the person he's speaking to is Shad, who is mentioned in other calls as well.
All right. Okay?
But that's the only identifier that we know is in the shop.
All right. Sir, Mr. Harvey.
I want to make sure we're making the appropriate distinctions here with regard to, and I understand the court's ruling, but I want to make sure that I get on record what I think are critical distinctions. Let's go back to when the court said, state, give us all your 801D2E statements that you're going to use during the trial of the, so that we can take these issues up now and not during the trial, just like we're doing. So number one, I do want to say that these alleged 801D2E, and I'm not agreeing that they are, statements that are now being proffered were not provided to us, and we didn't have an opportunity to litigate them pre-trial. And now we're doing exactly what the court didn't want us to do, number one. Number two, we're also talking about a confrontation clause problem because we have, for example, the pleas of guilty, admissions by co-defendants that are coming in that we cannot cross-examine. For example, precisely the ones that we are talking about now. Mr. Murphy, we know that beyond the hearsay argument, Judge, there is a confrontation clause argument.
Have you taken a look at U.S. versus Thompson? That is, that is 568 F APPX 812 11th Circuit 2014, and it talks about the right of a defendant to confront accusers. Thompson seems to indicate no, but I understand your point. I understand your point. I do.
But there's an 801D2E right of confrontation. There's an admission of a co-conspirator, an admission of theirs or a confession of theirs that we can't confront that presents a different problem, like a plea of guilty. We argued that with regard to Jefferson, and I think Jefferson versus the state is clear. So I want to make the distinction, state versus Jefferson, and I want to make the distinction because it comes in under a hearsay exception does not resolve the confrontation issue. And Mr. Nichols does not waive that confrontation issue, even if you find that it's a co-conspirator statement.
801D2E statements are not considered to be hearsay. They are, they're not.
I understand.
Okay, I just want to clarify. That's all.
I understand that.
Right.
And I want to make the distinction that because it comes in, there is a class of evidence that comes in under 801D2E. There's a class of evidence that comes in as admissions of party opponents. Those are subject to the confrontation clause, and we need to make that distinction.
Okay, and when I charge the jury, when I get down to that, yes, that will be a jury charge that I will probably need to hash out. But at this point in time, they're admissible for as a threshold matter, and the jury can weigh them as they see fit.
Okay. Well, admissions, I don't think are admissible at this particular point against Mr. Nichols.
Okay, but that's your
yes. And I want to make sure
that is your position at this point in time, and that has not changed. Right. And I certainly acknowledge that, sir, and will continue to mark that objection for you.
All right. Thank you.
Okay. All right. Unless there's anything else, I'm going to call for our jurors, okay?
No, I was going to say, in relation to the hearsay statements on the Instagram records, Your Honor, the state did redact any of the commentary that was on the bottom. We did keep what we believe Mr. Williams would have posted himself because it's his Instagram, but the commentary that's on below that we did redact, and I can show that to Mr. Steele prior.
All right.
that being, and I can show it to him now.
Do you want to show it to him now then?
Yes, Your Honor.
Okay.
And Your Honor,
Sir,
did you rule upon paragraph 4 of Mr. Williams' motion limiting number 51? What I just argued about the Porsche?
I'm going to overrule your objection, sir.
Has to have a continuing?
Yes, you may have a continuing objection, absolutely.
Thank you.